This video will focus on workers' compensation denials of primary liability in Minnesota. It contains general information and is not legal advice. Every situation is different and other laws might apply to your situation. Before we begin, we would like to introduce you to terms used in this video. DLI refers to Department of Labor and Industry. FROI, F-R-O-I, refers to First Report of Injury. NOPLD refers to Notice of Insurer's Primary Liability Determination. EDI refers to Electronic Data Interchange. SROI, S-R-O-I, refers to Subsequent Report of Injury. And NOID, N-O-I-D, refers to Notice of Intention to Discontinue Workers' Compensation Benefits. The term insurer is used to designate the claim administrator, insurer, self-insurer, or third-party administrator. DLI's goal is to improve the quality of denial notices by providing a framework for understanding, evaluating, and communicating the underlying basis for a particular denial. Denials must meet the criteria in applicable Minnesota workers' compensation statutes and rules to avoid being considered nonspecific or frivolous. A primary liability determination is a determination that an alleged work-related injury is or is not compensable under Minnesota statutes and rules. The NOPLD form informs all parties that the insurer is either accepting the claim or denying the claim. Parties to a claim may include the employee, the heirs or dependents of an employee, the employee's representative, the employer or self-insured employer, the insurer, or a third-party administrator for the insurer. Others providing benefits or services related to the alleged work injury may also be part of the claim, such as treatment providers or qualified rehabilitation consultants. If the insurer is denying the claim, a valid primary liability denial must include these steps. Step 1, investigate the injury. Step 2, determine compensability. Step 3, formulate and submit denial reason. And Step 4, distribute to required parties. Step 1, investigate the injury. An investigation, or a good faith effort to attempt an investigation of the claim, must be done on each claim before an informed decision can be made. What is considered an adequate investigation can vary depending upon the type of injury and whether the injury was caused, accelerated, or aggravated by the work activities. Although there is no specific requirement regarding how to conduct the investigation, an insurer often will make 3 contacts to obtain all of the facts. Contact generally starts with the employer to obtain injury details, confirm facts listed on the FROI form, and determine if there are any videos or witnesses to the injury. The insurer should also contact the employee to discuss injury details, treatment received, physical restrictions, and recommended future treatment, including their next appointment date. Finally, it is beneficial to contact the physician or healthcare provider to obtain treatment records for the current claim and to obtain return to work or workability forms. The healthcare provider must provide existing medical data within 7 working days of receiving the request. If you are having difficulty obtaining medical data, remind the healthcare provider that under Minnesota statutes, Section 176.138A, authorizations to release medical information are not necessary for a current alleged work-related injury. Investigations must be done timely as there are statutory deadlines for making an initial determination of liability. Taking time to review this statute in its entirety will help you to thoroughly understand various timelines regarding a denial or acceptance of primary liability. The following slides provide an overview of the timeline. Links to this and all rules and statutes can be found in the notes at the end of the video. If the employee is alleging lost time that exceeds the 3 calendar day waiting period, you must file with DLI. To be considered timely, file within 14 days of the first day of the disability or the date the employer was aware of the disability, whichever is later. To deny primary liability, an insurer must initiate an EDI-SROI 04 transaction that is accepted by DLI. If a claim appears to be questionable, but the insurer does not have a valid reason to deny the claim, the statute allows the insurer to accept liability, begin any appropriate payments, and then continue its investigation. If a valid reason for denial is obtained within the 60 days, the insurer can then deny the claim and terminate payment of compensation by initiating an EDI-SROI 04 transaction that is accepted by DLI. To discontinue payment and deny the claim after 60 days, the insurer must notify the department and all required parties, including the employee, with notice of the intent to discontinue benefits. The insurer does this by entering and submitting the appropriate EDI suspension transaction and creating the discontinuance web form. Notice must be served with all supporting documentation on all required parties. Step 2. Determine compensability. After all the information is gathered, the insurer makes its compensability determination. To deny primary liability, ensure the claim has been investigated or be able to document a good faith attempt to investigate. There is a legal basis to deny. Facts have been obtained that support the legal basis. Any denial that is clearly contrary to fact or law should be reconsidered, and supporting documents have been obtained. Step 3. Formulate and submit denial reason. Denials of primary liability must meet the criteria in statutes and rules to be considered specific and not frivolous. To be considered specific, the reasons for the denial must be clear and state a specific reason in language easily understood to a person of average intelligence and education. The reason for denial must state a legal basis and provide an accurate statement of facts concerning the claimed injury, or the denial may be considered frivolous. A denial must also show an investigation has been completed or a good faith effort to investigate the injury has been attempted. All referenced medical reports or other related documents must be attached to the denial. Some tips to consider. Avoid using abbreviations or industry acronyms in your denial language. You know what you know. Put it on paper. All facts should be documented. To avoid penalties, ensure the denial reason states a legal and factual basis and is specific and is not frivolous. Make sure what you are serving is complete and what you intended. Attach all supporting documentation to the denial. Ensure documentation is both uploaded into the campus file and attached to the denial when served. Keep in mind that campus has a limit of 500 characters in the reason field. If your denial reason cannot be completely incorporated within this limit, attach a separate denial statement. In this circumstance, DLI suggests stating in the reason field that the full denial reasoning is attached. Additionally, for any denial that relies on medical records or other relevant documents, the denial reason should clearly explain how the facts within the supplied records or documents support the denial. Step 4. Distribute to required parties. The insurer is responsible for serving all required parties with a copy of the NOPLD form and any supporting documentation. As a reminder, the department does not serve any documents. The NOPLD form can be found in Campus under the Documents tab. Check with your company for its preferred method of serving the NOPLD form, along with any supporting documents on all required parties. Resource links can be found below the video. The Minnesota Office of the Reviser of Statutes link is a search engine for all Minnesota statutes and rules. If you have any questions about the denial process involving Campus, contact the Workers' Compensation Division Help Desk at 651-284-5005 and press 3, or 800-342-5354 and press 3, or send them an email, helpdesk.dli@state.mn.us. For questions involving EDI transaction or submission issues, send the EDI team an email at dli.edi@state.mn.us. www.mn.us.